So with that introduction, let me turn it over to Mike Trackman and kind of go through status of non-competes and other protections. Mike.
Thanks, Kevin. Good morning to everyone. I want to talk about covenants not to compete being kind of the other side to the coin of what we just saw in that video, which is obviously we all know it's very, very difficult to recruit good people, but once you got them, you got to hold on to them. And the way that we've structured efforts to hold on to them for decades is kind of a default version of non-competes. And what I want to talk about briefly today is how that still works to an extent, but it doesn't work the way it used to. And there's some adaptation that you're all going to need, I think, to implement in order to hold on to your good people in addition to recruiting other good people. Next slide, please. So where are we? Those of you who have heard me talk at MEA presentations before know that I've been beating this drum for a couple of years now in respect to seeing kind of the contraction of non-competes on the horizon. And it's now getting to be in full bloom because of an announcement, an executive order that President Biden effectuated a few weeks ago, which has been wrongly characterized as the President of the United States banning non-competes, which he doesn't have the power to do. But President Biden did make a very well publicized presentation stating the administration's viewpoint, a viewpoint held by a lot of other states, that non-competes need to be substantially limited to restricted circumstances because they limit competition, people feel they're bad for the economy, et cetera. And what President Biden did do is to say the FTC, the Federal Trade Commission, should take a look at non-competes and see what might be done on the federal level. So there might be some things coming down the line at the Federal Trade Commission level in respect to non-competes. But the message is that through it all, non-competes are enforceable, at least in Pennsylvania, New Jersey, if they're done correctly, but it is getting harder to do it the right way. And I just want to touch on those issues now. This is all very important in what I've come to call the post-COVID business plan of many companies. And that is that as we all emerge, hopefully, from COVID, there are businesses, and I run into this in my practice all the time, there are businesses who are succeeding in one particular space, and there are other businesses in that same space who are not succeeding. And the businesses who are not succeeding are kind of looking around and saying, well, what is it that they're doing that we're not doing? Let's go get their key employees and find out. And there's a tremendous amount of poaching that's going on among competitors now, as those who are less successful coming out of the crises that we've all experienced are looking after those who are more successful and trying to get their key employees out of that company into their doors and then hold on to them. And that's made this entire topic much, much more stridently important so far as I'm concerned for purposes of success in the middle market. Thanks. You can click on the next part. So where are we in terms of covenants not to compete? The courts, as I said, are getting more reluctant to enforce covenants not to compete, and combined with the Biden statement, there seems to be a trend which is limiting that which is otherwise enforceable. There are judgment calls that courts make in the non-compete world, and those judgment calls are starting to trend against employers as opposed to for employers. The judgment calls with respect to the enforceability of a covenant not to compete focus on is there a legitimate business interest in respect to the enforcement of a covenant not to compete. A legitimate business interest means, is there something that a company is doing when it tries to enforce a covenant not to compete that is legitimate in the sense of doing something more than just trying to keep a good employee from going somewhere else? Is it that that employee has your trade secrets, has some special knowledge as to how you succeed in the market, as opposed to it being a good employee who has more or less generic skills, doesn't know anything in particular that's really of a tremendously secretive nature? And courts are basically saying in a pretty substantial trend right now that unless you can put that sort of icing on the cake as to why you need to enforce the covenant not to compete, there is no legitimate business interest to enforce someone from seeking to go from one company to another. Someone posed a question that I just saw in the chat as to whether or not the poaching is going from large companies to smaller companies. I'm not seeing that. I'm seeing smaller companies are poaching each other as much as larger to smaller and smaller to larger. I think that companies are looking to succeed and they're identifying other companies' key employees as a shortcut to the success. The other judgment calls the courts make as to whether or not a covenant not to compete is of a reasonable duration and within an appropriate geography, so as to protect the interests of the company that holds the employee. It's very tough to enforce a covenant not to compete anymore that's longer than 6 months or a year. There's some legal reasons for that, and the geography issue has to be limited to where your market really is. There has to be something of value given for the non-compete. You can do it, that's something of value, that consideration can be a new job, but trying to implement a covenant not to compete after someone's already been hired is more difficult. There has to be something substantial given in return, and that's getting to be looked at through a magnifying glass. And also state legislatures are now starting to, some of them starting to look askance at covenants not to compete. Massachusetts, California, Colorado, Connecticut, there's a lot of state legislatures that have limited the efficacy of covenants not to compete as we usually draft them, which is to say, you cannot work for a competitor in our field for X period of time in Y geography. That's how we typically see a covenant not to compete. Next slide. So with a covenant not to compete, in addition to the problems with enforceability, you've got some other issues as well. Will the best candidates be willing to sign a covenant not to compete? And will you diminish the candidate pool by virtue of imposing the usual standard boilerplate covenant not to compete? Will it diminish morale and commitment of your workforce by trying to enforce a covenant not to compete? These are all kinds of considerations that you need to consider if you're going to do it. Someone in the chat just asked a question is whether you can impose a covenant not to compete in an offer letter. The answer to that question is only if that offer letter is turned into a signed agreement at some point. You need an employment agreement, not just an offer letter, although you should advise your candidates that, excuse me just a second, that a covenant not to compete is going to be coming down the line. All right, next slide, please. So my advice is to change the standard boilerplate. Instead of having a covenant not to compete that says that you can't work for a competitor in our field for X years in this geography, make it something that's almost as efficacious for you, but something much more palatable both to courts and prospective employees. Say you can't work, you can work in your chosen field. We're not going to exclude you from that field, except for certain key competitors, for example. So the rest of the horizon is open for the employee. Or you can say you can work in your field. We're not going to exclude you from your chosen field of endeavor, but so long as the company that you're working for does not offer certain specific products or services, or you don't work in that department, for example, or so long as the prospective employer that you're going to go to does not deal with certain customers that we deal with. So you're effectively saying to a prospective employee, we're not going to bar you from working in your field. You can do it, but with these restrictions, which will generally protect your primary interests and make the covenant not to compete much more enforceable and much more palatable to your prospective employees. Next slide. A non-solicitation agreement is a kind of covenant not to compete, which you can combine with the traditional covenant not to compete, and it's much easier and much effective. You can say to an employee, all right, sign this. You can work where you want if you leave, but when you go work for somebody else who's a competitor of ours, you can't solicit our customers or our prospects, or you can't solicit certain customers and prospects that you dealt with when you were with us, or you can't solicit certain specific customers that we're particularly concerned about. Because oftentimes you really don't care whether or not someone is working for a competitor, so long as they're staying away from your customers, or so long as they're staying away from particular competitors. And you can make this work in that way oftentimes as well. Next slide, please. And finally, in addition to ramping back covenants not to compete into a more palatable form, in addition to using non-solicitation agreements, I would suggest that you consider some more strategic carrots as a means by which to retain your key employees, as opposed to the sticks. Carrots and sticks is going to be a big theme today, I know. Number one is engagement the culture of your workplace, the kinds of things that Kevin talked about before, the kinds of things that MEA is focusing on in future presentations as well. Obviously crucial for retaining your key employees, but there's also other means that I would suggest you take a hard look at that deal with money, frankly. One way to do this is to pay people a retention bonus. You're here for 5 years, you get a certain retention bonus as a result of that. Another 3 years, another retention bonus, a carrot in front of their nose that makes it more economically attractive for them to stay. You can have a bonus pool, for example, which is a structured way to tie bonuses to profits of the company. You can have what's called a change of control bonus, where you have a situation where many times employees say, hey, why am I working here and building up the value of this business? You're just going to sell it for $1 gazillion and I'm not going to see any part of the value that I added. You can structure bonus arrangements where upon such an event, key employees can in fact get a piece of that action, and that keeps them there because again, there is that carrot in front of their nose. And finally, there's something called phantom equity, where without giving employees ownership of a company, you can treat them as if they're owners in respect to profit distributions and the like. And that way they really feel invested in the company. They feel a part of the company. They're much less likely to leave the company. So with that, again, I stress that the key to this economy is not only getting good people, but keeping good people. And I think these are the techniques that you need to employ in order to do that. Thanks very much.
I think we had 2 questions. I mean, you may have gotten these, but one of the questions I think is relating to remote workers. And someone mentioned a 2-year non-compete, which I think is going to be long no matter what position it is. But what are your thoughts around kind of some of this remote stuff?
A covenant not to compete, if there's a legitimate business interest to back it up, applies to remote workers or in-person workers. The key is whether it's an employee who, if they leave, will cause you some harm beyond the fact that you just lost a good employee. It's somebody who knows your secret sauce. It's somebody who knows your customers. It's somebody who knows your pricing. It's somebody that you taught your operational methods that a customer would really want to get their hands on, as opposed to just losing a good employee. Remote work, in-person work, it doesn't matter. In terms of the duration of a covenant not to compete, the law is that the duration can be no longer than that period of time that it takes for you to kind of tamp down the adverse effects of losing that employee. So, for example, the classic situation is where you lose somebody in the sales department who has relationships with customers, and you're afraid that if they go to your competition, they're going to visit those customers and take your customers from you. Many courts will hold 6 months, a year tops would be enough for you to establish somebody else in the slot of that person who left, give that new person the opportunity without interference from the old person to establish relationships with the customers. And once that period of time has elapsed, there's no more reason to implement the covenant not to compete, let the competition games begin. So these are judgment calls. Different courts, different judges take different perspectives, but the trend is you better ratchet back the severity of the covenant not to compete in order to have a realistic chance of being able to enforce it. Think about non-solicitation agreements as well, and obviously culture and engagement, in addition to a profit motive to stick with you.
Okay, I'm going to spin the last question a little bit. So if you acquire a company and the employees of that company you're acquiring do not have good non-competes, is there a way to create consideration to create a new non-compete at that point of acquisition?
Yeah, I mean, there's different kinds of acquisitions. If you acquire the assets of a company, for example, and you formed a new company to take in those assets, and you are now employing those employees in a new company, which is taking over the business of the old company, but it's a new company, the mere advent of employment with the new company would be a significant enough consideration. But other than that, many times what we'll do is utilize signing bonuses, for example, or perhaps there is a new aspect to a deal, such as a bonus arrangement that an employee would be provided, so long as it's fairly substantial and meaningful, but some kind of a commission arrangement, a bonus arrangement, whatever works that the employee didn't have previously, that will work as consideration for a non-compete. It's got to be more than just kind of lip service. It's got to be something of value, but that can work, and oftentimes that's what we utilize.
And more than just continuation of your job.
You certainly can't do that. Continuation of a job is never sufficient unless it's with a new company altogether. So you're continuing your job, but with a new employer that bought the assets of your present employer.
You had to rehire, yeah. And then someone said if you change your non-compete agreement, you don't have to necessarily change the old agreement. You're just, you got two different agreements in place. I think.
Say that again, Kevin, I'm sorry.
If someone's asking if they change their model agreement going forward, they can still rely on the older agreement for prior employees that signed the old agreement. Yeah.
Yes, you can. And you can also, if you want to, you can change the agreement for your prior employees to make it less severe. So it's not a new non-compete that you're imposing on them, but rather it's a less severe non-compete, which you might want to do in order to up the odds that it will be enforceable should the time come. And because you're lessening the restrictions on the employee, you wouldn't need separate consideration for making something less restrictive as you might if you were making something more restrictive.
Gotcha. Great. Well, thank you, Mike, very much. That was very, very informative. And now we'll turn it over to Amy.